Hola, buenos días desde el webinar de la Asociación Española de Franquiciadores con nuestro socio colaborador Bird&Bird, en la cual hoy vamos a tener la tercera sesión con 3 países adicionales a los ya expuestos en las anteriores jornadas, que son Italia, Francia y Marruecos. Dado la importancia de dichos países, vamos a darle el paso ya a Lourdes para que organice y modere dicho webinar. Welcome to Spain. It's a pleasure. Lourdes, when you like.
Gracias, Eduardo. Bueno, buenos días a todos y bienvenidos. Muchas gracias de nuevo a la Asociación Española de Franquiciadores y a Eduardo, Abadía y Verónica Zarco por esta nueva oportunidad. Es un placer estar aquí con todos vosotros y con mis compañeros presentando el tercero de nuestros webinars, como ha dicho Eduardo, sobre la internacionalización de la franquicia. Como ya sabéis, una breve introducción. Bird&Bird es un despacho internacional de abogados que estamos en más de 29 oficinas distribuidas por todo el mundo. Tenemos un enfoque sectorial y uno de nuestros sectores en los que prestamos mayor atención es el de la franquicia. En nuestras oficinas tenemos 50 abogados distribuidos por todas ellas con ese enfoque sectorial y esa especialización, ayudando a nuestros clientes franquiciadores y también franquiciados a expandirse y crecer nacional e internacionalmente. En esta serie de webinars hemos tenido ocasión ya de repasar, como ha dicho Eduardo, varias jurisdicciones y hemos tenido la ocasión de comprobar cómo las diferentes legislaciones aplicables en los distintos países tienen unos elementos comunes que tienen como principal objetivo, sobre todo, proteger al franquiciado y a la seguridad jurídica relativa a la franquicia. Pero también hemos visto cómo las distintas jurisdicciones regulan los elementos de una manera diferente, que hay que tener en cuenta a la hora de internacionalizar el negocio a través del sistema de la franquicia. En esta ocasión nos hemos enfocado, como ha dicho Eduardo, en Italia, Marruecos y Francia. Os quiero recordar y os invito a todos vosotros a repasar las grabaciones que hemos hecho de los otros webinars, que hemos ya pasado por Inglaterra, Holanda, Polonia en un primer webinar y en un segundo webinar por China y Australia. Quería también invitaros a ver una herramienta que ponemos a disposición de nuestros clientes, que está, el link lo tenéis en los materiales que vamos a circular después, que se llama International Franchise Laws Tracker, en el que damos una visión y una pincelada de toda la legislación aplicable en las distintas jurisdicciones, muy numerosas y muy interesante para tener una primera percepción acerca de con qué nos enfrentamos cuando nos internacionalizamos nuestra franquicia en una determinada jurisdicción. Bueno, doy paso ya al foco actual del día de hoy porque es bastante largo y no quiero consumir los minutos que tienen mis compañeros. I switch into English now to make the presentation. Today's speakers first will be Italy. Will be Claudia Ricciardi and Rita Tardiolo. Claudia is a partner in our Italian office. She has considerable expertise in franchising agreements and the management of relationships with franchisees. And Rita Tardiolo in our Italian office also in Milan has expertise in franchising, IP, intellectual property, consumer protection law, regulatory compliance, and related contracts. So the floor is yours, Claudia. And nice to have you here.
Thank you, Lourdes. So we are very happy to be here, and thanks for having involved us. So we are pleased to provide an overview of our franchising law in Italy. We have basically franchising agreement regulated by a law that dates back to 2004. And prior to such date, we had no regulation of franchising. So regulation was basically found within the scholars' interpretations and within literature. We have then a ministerial decree that dates back to 2005, which implements law 129 of 2004 in relation to foreign franchisor entering Italy. So we'll get to that in a while. So franchising law provides, first of all, a definition of what franchising is, and it gets to three basic elements. First one is relates to the relationship between the franchisor and franchisee, which according to the definition have to be economically and juridically independent from each other. Second element relates to the grant of certain intellectual property rights from the franchisor to the franchisee and to the assistance, to the technical assistance that the franchisor has to provide to the franchisee. Third element relates to the fact that the franchising formula has to be tested already by the franchisor. So getting to the very last element, we have a sort of debate amongst the scholars as to whether the franchising law applies also to the first franchising, to the pilot franchising. So, you know, if you want to establish a franchising network, you have to start from a certain point. And the question is whether to the first 2 or 3 or 4 franchisees, the franchising law applies. The answer is a negative one. So it's a sort of, the pilot franchising is sort of a typical contract, which is nearer to trademark and know-how license with the services provided by the franchisor. On the other hand, with respect to those franchisors that are going to enter into Italy with a network that has already been started and tested abroad, apparently the law allows, and the ministerial decree allow that no specific test is carried out on the Italian territory. So it is an interpretation, obviously, but we have elements within the law that lead us to think that no specific testing in Italy is required. With respect to the content of the law, of the elements that feature the franchising, the definition mentions the grant of intellectual property rights and the provision of services. And with respect to intellectual property rights, it relates to trademarks and know-how, as well as models and so on. In this respect, we have a decision of the Supreme Court, which dates back to 2018, which is quite interesting because it seems to say that not all such elements are required, and particularly in such specific case, the know-how was lacking. So the interpretation of the Supreme Court in such case seems to suggest that not necessarily we need to have a know-how license within a franchising agreement. I'm not sure whether this is an interpretation and the decision that will be followed by subsequent decision, but it is quite a key one because it's the first time that this was stated. The first element that is suggested by the definition of franchising within the law relates, as I was saying, to the relationship between the franchisor and the franchisee. So the law states that the franchisor and the franchisee have to be economically and juridically independent. This has set a number of debates among scholars and also some most recent case law. Indeed, first of all, the question is whether such requirements imposes that a franchising agreement cannot be executed between companies belonging to the same corporate group. This is as well debated because amongst companies belonging to the same corporate groups, obviously the juridical independency might lack. On the other hand, we have a decision from a court of Bologna, which is dated 2016, which states that in the event that the franchisor is very present, as an intense presence in the activity and the business of the franchisee, the economic independence is lacking, and lacking economic independence, and so having the franchisor very present in the activity of the franchisee, in the business of the franchisee, would lead to the nullity of the contract. So in that specific case, on the basis of all the provisions, a number of provisions that were included in the agreement, the court stated that the agreement was null and void, and ordered to the franchisor to return to the franchisee the amount paid by such latter party. So we have to be very careful, and this is an exercise that we're doing with a number of clients in checking whether the clauses of the agreement entail a too intense presence of the franchisor within the business of the franchisee, such that there is a sort of interference and the franchisee is not basically anymore entitled to run the business at its own risk. So this is quite a crucial element to be considered in revising the contracts. Getting to the content of the law, the franchising law is focused on two different sets of clauses. The first one relates to the pre-contractual obligations, so to the negotiation phase. The second one relates to the mandatory content of the agreement. So with respect to the pre-contractual disclosure requirements, basically half of the 4 pages of our law are dedicated to such aspects. This is basically to ensure that the franchisee, which is the weaker party, which is seen as the weaker party of the contract, takes an acknowledged and informed decision as to whether executing the franchising agreement. And for such purpose, the franchisor is required to provide to the franchisee at least 30 days in advance of signing the franchise agreement, a copy of the franchise agreement to be executed, and a number of information to be included in the annexes, which relates not only to the data and information of the franchisor, to the indication of the trademarks, as well as also the licenses, possible licenses granted to the franchisor, a description of the franchising activity, a list of the franchisee operating in the franchising system, and also the franchisor's direct point of sale, and then an indication on a yearly basis of the changes in the number of franchisees together with the indication of their location for 3 years. Last, a brief description of the juridical and the arbitration proceeding brought against the franchisor and closed during the last 3 years in relation to the franchising system. So you may see that it is quite a burden in the pre-contractual phase, and failure to provide some of those information to the franchisee may entail the rights upon the franchisee to cancel the contracts. So this is something that is has been quite a new approach under Italian law, because we have no other laws that provide such an intense pre-contractual obligation disclosure. With respect to the, can you please get to the next slide? So we have, I mentioned it beforehand, that we have the Ministerial Decree 204 in 2005 that relates to the companies entering Italy and having already operated abroad. So in such specific case, the legislator allowed that certain information was a bit, have to be provided in quite a simplified way. And for instance, with respect to the number of franchisees and franchisor direct points of sale, we can provide just a country by country information, and also a list of the location of the 20 operative franchisees. So requirements, pre-contractual requirements are a bit differentiated with respect to those franchisors that have operated abroad and are going to enter Italy for the first time. The question is basically how long does these simplified pre-contractual requirements apply? And according to some scholars, this simplified pre-disclosure obligation applies during a 3 years, would apply during a 3 years period from the first from entering into Italy. With respect to the content of franchising, we have a number of mandatory clauses that are provided by the legislator. First of all, please consider that the franchising agreement in Italy has to be in written form, otherwise it would be null and void. And we also have a minimum term, which is 3 years, or such longer term that is required to amortize the investments. This means that withdrawal, so termination without cause, is not allowed under Italian law with respect to franchising agreement. You are entitled to terminate the agreement for breach, but not without cause, basically. So with respect to the content of the franchising agreement, we have a number of provisions that have to be included. The debate among scholars is whether all those elements that we have listed here from A to G have to be effectively included in the agreement. First of all, the indication of the amount of the investments. This is regarded as a crucial point. Again, this is aimed at having the franchisee undertaking a decision, an informed decision as to whether conducting this franchising business or not. Then we have the indication of the method of calculation of payment of royalties. Possible exclusivity, and the legislator here has included the possible, such that exclusivity is not regarded by the literature as a mandatory element within franchising. Then description of the know-how, which I was saying was regarded as a main and the feature elements of the franchising, except that the Supreme Court seemed to state something different in 2018. And then we have the indication of the characteristics of the services offered by the franchisee and the conditions for renewal, termination, or possible assignment of the franchising agreement. So those are elements that have to be included. A couple of those, as mentioned, are really optional. The very question with respect to foreign franchisors is whether the franchising law, Italian franchising law, is mandatory or not. So the question is if we have a franchisor that is a foreign entity and it executes a franchising agreement with a franchisee based in Italy, do we have to apply Italian law? Again, we have a debate on this because franchising law relates to the, seems to suggest that it applies to those franchising contracts that are executed and performed in Italy. But rather, the decree the 2005 decree seemed to allow, on the other hand, seemed to state that franchising law applies if so elected by the parties. With respect to those, then we can say that a foreign law may regulate franchising agreements with franchisees in Italy. And at this point, the question again is whether some of the provisions provided by the franchising law have to be necessarily contemplated in the law or not. We have the major orientation that states according to which the clauses, the provisions of the franchising law are not mandatory. According to a minor orientation. We would have some of the provisions of the Italian franchising law that would have to be necessarily contemplated in the franchising agreement, irrespectively of the law that regulates the contract. In this respect, this is basically because the franchisee is seen as the weaker party of the contract, and so this law is seen as a sort of laws protecting the weaker party. So these minor orientations moves from such assumption, and following such orientation, such minor orientation, we have certain provisions that would relate, for instance, to the fact that the agreement has to be in written form, and the pre-contractual obligations are seen by these scholars as, for instance, mandatory, as well as the norms on the minimum terms. So those are the main features. I would leave now the stage to Rita. Rita is going to explain which are the most recent cases with respect to the application of a law provision, which is not really dedicated to franchising, but has found really an application, a broad application on franchising, which is the abuse of the economical dependency. I mentioned it beforehand that a feature of the franchising is the fact that the parties have to be economically and juridically independent. And the dependency in such respect was seen as not having the franchisor not interfering with the business of the franchisee. Now Rita is going to provide us a different sort of different meaning provided by a different law with respect to the economic dependency and relevant abuse. So Rita, up to you now.
Thank you, Claudia. Thank you, everybody, for involving us. Yes, I'm going to focus very briefly on the concept of economic dependency and its abuse and the consequences. Claudia has already said that the contract can be void, but there are also many other consequences that you have to be aware of, I think. The law dealing with this subject is as Claudia said, a law that was issued for protecting suppliers as weaker contractual parties. And so it was focused on, it is focused on supply agreements, but the courts have in many occasions said that this is a law suitable to be applied also to different type of contracts, including franchising agreement. And in any case where there is the need to protect the supplier, which is the weaker contractual party. So very briefly, when does economic dependency occur? Of course, when there is disparity of rights and obligations between the parties of the contract, when there is a lack of chance to find alternatives on the market for the weaker party, which are satisfactory for him, and so he is in difficulties in this case. This is the dependency, but the abuse, what about the abuse? The abuse, you find that the abuse, we will see some decisions dealing with this dependency, which stated that you have the abuse when there is the imposition of burdensome conditions in the agreements, when there is an arbitrary interruption of the contractual relationship, and of course when there is the refusal to sell or buy from the weaker party. But going more into details in these cases, which have been dealt by the Italian Antitrust Authority. And why by the Italian Antitrust Authority? Because this dependency and the abuse in most cases can be relevant for the protection and of the competition and the protection of the market. It is important. I will start from saying just one thing about sanctions, because they can be very high. The sanction applied in this case by the antitrust authority is a pecuniary administrative sanction and can be up to 10% of the turnover achieved by the company, putting on the market this abuse or in the last financial year. So I will end my speech with an example of a quite high sanction. The first case that I want to explain is related to McDonald's franchising. Everybody, I think, knows McDonald's. McDonald's is the leader in fast food restaurants with a position that is, if not dominant, at least of great supremacy in Italy. I'm talking, of course, about McDonald's Italy, but as a company part of the McDonald's International Group. And in this case, there were some claims of some franchisee of McDonald's in front of the antitrust authority, and the antitrust authority started very recently, because it's dated back last July, so July 2021, and started an investigation. So we don't have a decision here, but just an investigation, because the antitrust authority alleged, due to these claims of franchisee, the possible abuse of economic dependency by McDonald's. Why? Towards this franchisee. Why? First of all, what were the elements of economic dependency that the antitrust authority is found and is going to further investigate? But of course, the fact that there is a different size, there was and there is a different size and market position between the parties in the franchising agreement. McDonald's on the one side and the franchisee, which are people who intended to undertake a restaurant business on the other side. Then the fact that the franchisee were de facto obliged to accept the terms of the affiliation without knowing before the details of this affiliation, just by way of adhesion. Then the conclusion of contracts of long duration, 20 years, and the position of contractual provisions which are likely, the investigation is ongoing, to create an excessive imbalance of rights and obligations. And of course, and last but not least, the franchisee's difficulties in exiting the contractual relationship, recovering the investment, and finding, as I said before, a satisfactory alternative. The elements, these are the elements of the dependency, economic dependency. The elements of the abuse of this economic dependency recognized by the antitrust authority were, inter alia, the obligation to comply with precise indications from McDonald's on many elements of the business. For example, the product prices, the policies defined unilaterally by McDonald's on promotions, procurement, supplies and purchase orders. So no independency, no possibility to make choices on its own. And of course, the fact that the economic conditions for entering on the one side and leaving McDonald's system were particularly onerous. We will see how it will end. I think that the end of the proceeding is fixed by now, by the end of 22, so we will have to wait a bit. My time is going to end, but just to mention that there is another investigation ongoing against Benetton Group, which is, of course, an important clothing producer and marketer. And also in this case, there have been some claim in front of the antitrust authority by the franchisee. And also in this case, the antitrust authority has opened an investigation against Benetton Group, alleging abuse of economic dependency. I think that if you are interested, I can provide you with more details, but more or less, both the elements of the economic dependency and the abuse of this economic dependency are the same as those recognized in the case of McDonald's. Just making an example, the authorities said that Benetton, in view, has contractually guaranteed to himself the possibility of laying down rules and organizational parameters capable of making the franchisee's business structure rigid, not independent, to the point of preventing the reconversion of this business with another party at the end of the agreement, for example. In this specific context, the subject of the investigation of the authority is, of course, the use discretionary by Benetton of contractual clauses similar to those that we have seen for McDonald's, allowing to influence the retailer's strategic choices. So again, no independency and no possibility to find a strategic alternative on the market. The very last case I want you to know is about Poste Italiane. Poste Italiane, which is of course the leader in Italy. It was the only one till the liberalization of mailing services. After the liberalization, there have been on the market some minor competitors. Some of them, like these solutions, entered into agreements with Poste to service agreements for mailing services, of course, in certain area of Naples. And from 2012 till 2017, Poste Italiane really imposed many obligations and many burdensome conditions to these little competitor compared to Poste, so that the consequence at the end is that this competitor had even to stop the relationship with many of its workers. This is a very interesting case. I could give you many details, but if you want, you can get in touch with us. But what I wanted to highlight now is the amount of the sanction here, because we are not talking as for the other cases of an investigation. The investigation here is ended, and the antitrust authority has ascertained the abuse, and so imposed a sanction of more than 12 million to Poste Italiane. So this is, I think, a good reason to pay attention to all the applicable laws and conditions when entering with a franchising the Italian market. Thank you.
Thank you, Rita. Thank you, Claudia and Rita. This has been very interesting for sure. The fines have to be taken into account. of course. Now we will give the floor to our two colleagues, Alexandre Bouchot, who will speak about France. Alexandre is a partner in our international commercial group based in Paris, and he assists on commercial contracts covering distribution, franchise, sales, agency, cooperation, and procurement arrangements. And then we will, Alexandre will give the floor to our last speaker, who is Zineb Mowati. Zineb is an associate working from our offices in Dubai and Casablanca, and she will talk about Morocco, jurisdiction and applicable law. So the floor is yours, Alexandre. Thank you.
Thank you, Lourdes. Hello, everyone. Thank you very much for hosting us today. So I think it was a very interesting presentation from Italy. So I tried to demonstrate and show also how it works in France. And you can see that with different principles, I think the goal and the spirit of the franchise apply equally. So maybe to start from the very beginning. So for France is very often considered to be the country or the kingdom of franchise, because it's really one of the countries where the franchise network agreements have been very successful and are considered to be really one way for people to actually start the networks and start creating their own operations. But by contrast, there hasn't been any specific franchise law being implemented. And actually, for the time being, franchise is to be considered as a commercial agreement subject to generic French commercial law. But we'll see afterwards that there are some specificity which really apply to franchise agreement. But it's important to understand that at least 3 criteria are being used to consider a commercial agreement to be seen as a franchise agreement. They are listed here. There are 3 elements that you will probably see in most countries, so I would not detail them so much. The obvious one is the provision of the know-how, which is probably the most peculiar element of the franchise agreement, which really makes it distinct from a traditional licensing or trademark agreement, which may apply in other type of distribution. But so the combination of know-how and licensing of trademark are really 2 important elements. And the third one, obviously, is the permanent and ongoing technical assistance. It's not so much that you get a know-how or a trademark, is you can actually rely on the franchisor to actually make the concept evolve or provide some assistance. So it's really the combination of the 3 that makes it a franchise agreement, even though the very concept of franchise agreement is not recognized. The next slide, please. So one thing is to go in line with that is obviously everybody associates the franchise agreement with pre-disclosure agreement, which we've seen in Italy applies almost with the same principles. So this pre-disclosure requirement actually applied to many agreements where there is some exclusivity. So franchise is one of it, but obviously a very important one. It comes actually in addition to French general principle of pre-contractual duty for every contractor in France to provide some sufficient information for the contractor to sign in good faith and in knowledge of what it is signed. So it's really a combination of general civil law, commercial law, and pre-disclosure requirement applicable to all exclusive agreement. And we're going to see in the next slide what the content of these, what we call the PDD work. So very similar to what you've seen from Italy, there is a number of listed elements, which I will not comment on every single item in the interest of time. But you can see that there are some very basic elements, such as the address, the identity, some even useless, I find, elements like the banking reference. I mean, who cares that you need to provide that? Obviously, the trademarks. Most importantly, and sometimes a more difficult element, is the description of the main terms of the franchise agreement. There's always a question is whether you should actually disclose the entire agreement before it is signed, only a summary. So it's always, excuse me, a difficult balance to find between proper disclosure, explanation about the contract, or just describing the main terms. So it's a question of how you want to operate your business, to what extent you want to cooperate with your franchisee, and really have them understanding what they're signing. So our recommendation is always to be very much explicit, and rather than to copy really the exact terms of the agreement that they will sign at the end, try to make a more summary of practical terms and the impact it will have on their operation. So it's a very important element, and we'll see why, for the franchisee to really understand what they are signing, and this prevents you from risk and disputes in the future. So we can go to the next slide. So one practical consideration, and it's market practice here in France, is obviously the PDD is very important, because we have seen a number of details. It needs to be signed 21 days before the franchise agreement is signed. And there's been a lot of litigation about whether people had respected the period, the cooling off period, and the 21 days before. So it is market practice to use platforms where actually the pre-disclosure documents is being uploaded and signed by the franchisee, so that there's no ambiguity about its content and when it was delivered. So it's just a practical consideration, but just to let you know, that's market practice to provide that way. It can be homegrown or used by service provider, but it's a quite efficient way of getting off any disputes around whether this PDD was used or not. Okay, if I can go to the next slide, please. So another question we often receive from international franchisor is whether there is any requirement to operate a franchise network. So the question is very simple. As you can see from the slide, there is no registration requirement. It's just to set up a company, or not even that. You can it's very easy to operate even from an outside country. You don't need to have a presence in France. So no requirement, so it's quite open. Going back to something which is less funny, and why I insisted on the importance of having a pre-disclosure file being ready, updated, and signed in due course, is obviously the sanctions that can apply to a franchisor if this is not respected. One thing is criminal fine per breach. To be honest, this is never enforced, or very rarely, so it's not so much this sanction that should worry the franchisor entering into the French market, but it's more in case of litigation where franchise is not a success, and for some reason it is a failure. The one thing that every franchisee will try to do is to demonstrate that actually the pre-disclosure requirement were not satisfied, or that the information was misleading or not complete, so that it could A, cancel the agreement, but also, and more importantly, demonstrate that the lack of information of the franchisor has resulted in a loss. So it's really important to demonstrate that the pre-disclosure file is as complete and as fair as possible, just to avoid this possible sanction. Again, not so much on criminal, that's a theoretical risk, but more on commercial and about the consequences of cancellation of the agreement. I'm not going to go now through a couple of mandatory local laws which apply to franchise. They are not only to franchise, but they are very important to know. The first one we just discussed, so that would be very quick, is this pre-disclosure requirement referred to Dublin law, but we can go to the next one, please. The other one is, this is probably the most, probably the most important part at the moment. And if you go back to the presentation of our Italian colleagues, it's really about the abuse of economic power and the situation about imbalance situation between a franchisor and a franchisee. So it's a very important commercial principle, which it's really, and just to read it to make sure that everybody understands, is to it is prohibited for a party to subject or attempt to subject a trading partners to obligation, creating a significant imbalance in the right obligation of the party. So it's very sort of broad terms, very close to what you would normally find in consumer protection when you're trying to protect the weak against the strong. And it has been a lot of case law at the moment in many areas of the laws and sectors, but in particular in the franchise industry. The purpose of this clause is to make sure that for the plaintiff party to obtain the nullification of the clause, or if again there is we can demonstrate that there is a damages that results from the enforcement of this clause to be able to recover such damages. Why it is also important is because it's public law order. All the limitation and liability cap you would normally have in your agreement would actually not work in this situation. So it's actually makes a very unlimited risk of liability if the clause are considered to be significantly unbalanced, but I will detail a little bit later how we can assess that. If I can go to the next slide, please. Another very important area of dispute, very much so applicable to the franchise, is termination of commercial relationships. So again, it's about all commercial relationships, so it does apply to franchise as well, or to supply agreement, which can be associated to a franchise agreement, which is really to make sure that a sufficient notice period is being granted to the contractors when a decision is made to terminate. So why is this difficult? Because normally, in most countries, you actually look at the terms of the agreement and you apply the terms of the agreements. So if you have a notice period of 3 months, you apply a notice period of 3 months. Unfortunately, or fortunately, depends where you stand. In France, you're looking not so much about only the contractual provision, but also the overall duration of the commercial relationship. And then you apply a notice period which is proportional to that duration. So for instance, a duration of contract of 12 years or 20 years, you would need to provide at least a termination notice of 12 months, even though your agreement would contain a termination notice of 3 months. So there's a lot of case, probably, so I think last count was like 300 Court of Appeal case last year. 40% of the case, 60% of case are successful. So it's really an area where you need to be aware of, especially coming from different countries, because it's not obvious to know that you cannot just rely on your contractual provision. Going back to one thing I wanted to notice is not specifically to France, but it goes with the fact that we're talking about unbalance and abuse of economics, or the fact that the franchisee need to comply with the terms, but at the same time to find a balance is how the franchise agreement interact with the operation manual. Because we've seen in practice and in some case law, some difficulties where the agreement is disclosed and it's operating, but actually a lot of provisions which apply to the franchisee daily operation, including on price or processes, are actually being contained in manual. And the manual is in control of the franchisor, as you all know, and it's quite difficult sometimes to see to what extent you can actually change the manuals without requesting the consent of the franchisee. So on the one hand, it is recognized that you can control your network, your know-how, and the way you operate. But at the same time, you also need to make sure that if the changes are not too material, or you give sufficient time to the franchisee to adapt to the new conditions. And for instance, if there is new investment to be made, because again, there is always this, going back to the principle I described, and intend to make sure that there's sufficient time so that it's not brutal, or it is balanced so that you do not put too much onerous conditions on the franchisee. So it's a very slight, subtle balance to find between what's in the agreement, what needs to be amended, and what can just be changed into the manuals. So there is some flexibility, but I think it's important when you're entering the French market to understand how this works. Just give you an example to illustrate what we've been discussing about franchise, the difference of bargaining power between franchisor and franchisee, and the significant imbalance. There was an investigation from the DGCRF, which is the competition authority in France, that actually investigated the fast food franchise market, which is, as you all know, very much controlled by very large international companies, and most of the time the franchisee are small units, and we refer to McDonald's, but it could be smaller one. So there is really a situation where the two parties are not on equal foot. So I will not go into every detail of every findings of the DGCRF, and the slides are here for you to look at. But it is interesting to see how the regulators and how courts may thereafter look at how your agreement is being structured, to what extent it could be balanced or controlled. And one key element to have is to always try to remember that if a right is not balanced or unilateral, to try to explain why, so to substantiate why it is important, for instance, to get this right or this right, or when it is unbalanced, how it is sometimes also the counterpart of something else. So always trying to find in the drafting of the agreement, making sure that people are getting what they have for a reason, and not just because you want, as a franchisor, to impose conditions on the franchisee. So just doing an example on the royalty, is perfectly fine, obviously, to provide any type of fee for the franchisee to pay, but it's important to say what is exactly the service or the know-how or the content of the fee the franchisee will get. So it's important to get into these details. So not illegal, but very important to make sure that it is for a counterpart. If I can go to next slide, please. There is always this question as well, very important for international franchisor, is the language. As I said, there's no mandatory provision that apply to language. So you could very well have an English version of the agreement. It's not illegal per se. The problem is, and this is one of the findings of the DGCRF, and is that sometimes it's considered to be significantly unbalanced for a small company to enter into an agreement in English, because it's considered, rightly or not, that the small franchisee will not have sufficient command of English to understand what it signs. So obviously that's an important element to take into consideration for international franchisor. As far as the pre-disclosure file is concerned, making sure at least this is in French, understanding and describing what will be in the agreement. But also, and this is could be one recommendation, is to ensure that a proper translation or a French version is made available to the franchisee. So, I mean, we could go into other details. I think this is not theoretical risk. I've taken the fast food franchise market as an example because there was this investigation. There are other pendings, and some actions have been taken following these inquiries. The actions from the authority can take different form. It can take just a form of an injunction, and asking, for instance, the franchisor to delete one provision of the agreement or to balance it or whatever, trying to just making sure that the agreement would be, at the end of the day, more balanced. But more importantly, and actually there is an action being pending against Subway, the restaurant, for cancellation of the agreement and cancellation of all the significantly unbalanced provisions. So it's not only injunction, or it's just not reminding of the law. There's actually proper action taken against franchisor by the DGCRF or the Ministry of Economy to act let's say, on behalf of the small franchisee who do not have the knowledge or the means or the energy to fight against large franchisors. So actually it's the Ministry of Economy taking the lead to make sure that the agreement will be, at the end of the day, more protective of the franchisee interest. And one of the, for instance, the question we have a very interesting point on Subway case was in relation to arbitration, for instance, where the Subway franchise agreement was subject, I think, to New York law and American arbitration. And this was exactly considered to be completely unbalanced because no franchisee has the means to go to New York and have an arbitration to defend itself. So obviously we could go into many other examples, but just something to remember for today is that these agreements are being watched, and there are means, either individually or collectively from the state, to actually take action if the franchise terms are really too onerous. I don't want to be too paranoid or too risky, because obviously this is just for very large franchise networks. So entering into the market, as I said, France is the kingdom of franchise, so it's very open and easy. But it's important to understand that there are some risks, and question of fairness and balance is key. So I'm available for your questions if you have things on dispute or what are the areas, but just conscious of time, I'd like to give the floor to my colleague Zineb to just give you a flavor of what happened in Morocco.
Hi, everyone. Thank you for this very complete presentations. And as Alexander said, I'll try to give you a very quick flavor of what's happening in Morocco. So basically, franchising is governed mainly by the will of the parties, by the contract and ordinary law. And currently, there is a real debate as to whether or not to adopt specific framework for franchising, as some see it as, of course, providing flexibility, while others see it as creating a legal void. So negotiation and drafting are particularly important while entering a franchise agreement. Well, we'll try to see how the relationship between franchisee and franchisor is governed at each stage of the relationship. Yes. Sorry, I think I have a small. Can you hear me?
Yeah, we can hear you well.
Okay. I think I have a small problem here. Okay. Pre-contractual information is absolutely not covered for franchisee. Of course, there's the Moroccan Franchise Federations founded in 2002 that has adopted a code of ethics, which has no legal force actually. Next slide, please. So we can maybe focus on the enforcement of the franchising contract and the termination of such contract. As I said, it's mainly governed by the will of the parties, because the principle is that all contractual obligations apply to the parties. For the termination of the contract, there is no legal notice of termination of the commercial relationship between franchisor and franchisee. You just need to have two cases in mind. First case, you have a fixed term contract, and in this case, the contract applies. So when it's concluded for a fixed term, each party shall perform it until the end of the term, unless you have a notice period provided in the contract. In the second case, you have open-ended contract. So of course, there is no perpetual commitment. So each party is free to terminate an open contract at any time, but we need to be very cautious with the qualification of abusive termination. And in this case, the exact same principles of French law and French case law applies here. So the Moroccan case law follows French case law developed by Alexander before. So I will not spend more time on it because the principles are exactly the same. When you are foreign brand, you need to be also very careful about foreign exchange regulation because, I mean, the payment by the local Moroccan franchisee to the foreign franchisor of the franchise fees, so you have the guaranteed minimum fees and the entry fees, requires the prior approval of the Moroccan Foreign Exchange Administration. Without this prior approval, the franchisee won't be actually able to pay the franchise fees. So this is something we need to keep in mind. So this is what we have about specific regulation regarding franchise in Morocco, but of course you have all the other material regulation that applies, and you have, of course, IP and trademark regulation and competition regulation. IP is regulated by a law which has a very broad scope of application because it concerns any innovation, any invention, any innovation, it covers basically everything. So it's very large, and we have also a very large definition of the trademark or service mark, as it's defined as any sign capable of representation, which is very broad. The ownership of the trademark is also very protected. You can actually register with the Moroccan Office of Industrial and Commercial Property, which guarantees a protection of 10 years that you can renew. It's the innovation here is that it's now very quick because you can do it digitally. You don't have to be on site to do it. And this is part of the Moroccan business clean, I would say Moroccan business climate improvements. You have also a very strong, I would say very strong sanctions that can apply in case of violation of the property rights. So you can obtain the seizure or destruction of the products. You can also have very strong penalties that can apply here, going to 1 million dirhams, Moroccan dirhams, and you have also sanctions of imprisonment. So that's I would say the big picture of the protection of the trademark in Morocco. I'll go very quickly to our next slide concerning competition regulation. The competition regulation in Morocco knew the most significant development, I would say, with this new law 699, with again a very large scope of application, a very strong protection on the market, and the new status of the Competition Council, who tried to strike this last year, particularly very strong sanctions to give the example and to make understand that the market is being here very, under control. And we had, as I said, strong sanctions towards very well-known brands in Morocco, just to give the example. So Morocco is an emerging market. So the franchise market is booming, and our team has accompanied in the last month, very well-known brands just like Costa in the food industry, or Accor in the hospitality industry. So we are focusing on this matter this time, because it's very important for us. That's all for Morocco. Thank you.
Booming market. Thank you.
Thank you. Thank you all. Okay, well, I think we're done with our speakers. Very interesting. Thank you very much. It's very striking from a Spanish perspective, the fact that some, or in these jurisdictions, the public authorities can get into the actual contract, as Alexander has explained, and I suppose also in Morocco, from what I understand of the presentation, and the fact that in Italy also there are such big consequences of the economic dependency, which in Spain we do have the concept, as you know, but the consequences are completely different. They impose longer periods for termination or things like that, but never, at least up to now, maybe they get ideas from other jurisdictions, but up to now our judges or public authorities don't impose any such sanctions or fines as in other jurisdictions that we've seen today. And from what I understand, neither in other jurisdictions that we've reviewed up to now. So these are your specificities are pretty important to get to keep in mind. So this is all for us. Maybe we can, Veronica, I don't know if we have questions in the chat, or you want to make any question, Eduardo.
Sí, tenemos una pregunta, se sale un poco a lo mejor del tema legal, pero nos pregunta por el sector de belleza y estética. ¿Qué nivel de implantación tiene en cada uno de los países y un poco pues oportunidades y demandas en cada uno de ellos?
Let me translate, Veronica. We have a question on the beauty sector, and yeah, maybe it's not strictly legal, but they ask you, in your experience in your respective markets, if you can give them a flavor of the importance of the market and the opportunity of that sector, and the opportunities that you can see, or the developments that you can see in the particular sector.
I can comment if you want, just on, I mean, the beauty and cosmetics and very important markets. So it is indeed an important area development. There's two elements which sometimes can be of an issue, is if the beauty comes close to what could be considered as medical or regulated, especially if you use some medical devices. For instance, there have been some issues around franchise that wanted to do whitening teeth. I don't know if you're familiar with that. And obviously there was a lot of lobbying from dentists considering that you could not do things. The same thing would happen, I'm sorry, I'm not familiar with the English terms for epilación, ¿no? ¿Cómo se dice?
Yes.
Depilación.
Sí, depilación.
Bueno. So it's always this boundaries, which is quite difficult sometimes to fix, between what is regulated but this highly powerful body of medical and professionals which are regulated, and some operators like franchisor who would like to develop new concept. But globally, you can, but there's always this, especially with new products or new medical device, not medical device, new devices that can be quite close from medical device where there can be some issues. But it is a very important market, and for instance, the nails, everything about the hairs, skin works pretty well.
Yeah, same for Italy, basically. And we had a number of franchising in the makeup area. We have also assisted a number of clients in that respect. We have also direct points of sale, for instance, by L'Oreal. So not all the players use the franchising formula, but it's going to be, it's really under development. Same for hair, and comments from Alexander also apply in Italy.
Yeah, I would just add that cosmetics are every day more and more considered luxury goods, and indeed, big fashion group have all their cosmetics line, and also influencer dealing with the fashion are now making partnership to have their line of cosmetics. So I think it's a big trend now.
Absolutely. It's a little bit hard to come at the end because there's nothing left to say. You're very
next time.
Comments. Same from Morocco, yeah.
Okay, I think any other question, Eduardo, that you want to pose, or?
No, for me it's very, very clear to the exposition into the French, Italy and Morocco is a different market, of course, but it's perfect, your presentation. It's very, very clear. Thank you very much for all. Congratulations.
Thank you all. So we may close now, and we'll be, of course, as usual, at the disposal of anyone who wants to reach out directly to our colleagues or through me.
Thank you. Okay.
Thank you, everybody.
Thank you very much.
Bye.
Bye, everyone.
Bye, everybody.
Bye.